Hey, it's James, Father's Rights and Resources, hashtag how I got custody. So, everybody should learn and know the rules of evidence. When you go into court, what's allowed in court is governed by the rules of evidence. If you're playing any kind of game board game, or, well, there's rules to everything in life. There's rules of the road, everything like that. But if you're, the best example is, a boxing match or wrestling where you have to cut weight. If you're a middleweight fighter, Mike Tyson can't walk into the ring and fight you. He has to show up at the weigh-in and qualify to get in there. He's disqualified once he doesn't cut. I don't know what the middleweight is. Maybe let's say it's 170 pounds. And so if Mike Tyson is 220, he's not allowed in there because it's not fair. So the rules keep out any middle. And if you're a middleweight, you don't have to fight somebody over 170 pounds because it wouldn't be fair because they got more weight and all that stuff. So even the greatest middleweight is going to have trouble with an average heavyweight, right? So the rules are set to not allow stuff into the ring. There's the evidence rules do not allow stuff into the courtroom, into the ring. They're not allowed in. Now, sometimes a pro se will object, say, objection, hearsay. The judge will say, oh, wait your turn, then you can argue your objections later on. No, you stupid, dumb, airheaded moron. Stuff that's not admissible is not admissible. They're so stupid. It's not admissible right now. You don't allow it to come into the room and then float around the room and get in there. It's like a bug. Like the screen door is there to keep out bugs. You don't allow bugs in and then you deal with them later. You try and keep them out with the screen door. So the evidence rules are like a screen door to keep stuff out that's unreliable evidence, or evidence that could be tainted, or whatever evidence that in criminal court, if you are a drug dealer and they seize the drugs without a warrant, that's inadmissible because if they allow that, they'll start allowing cops to just ransack homes everywhere. So, um, so that's just for people who don't know anything about the evidence rules. It's so pertinent because an attorney can bring in a whole bunch of stuff. And I talked to a guy today, an attorney said, oh, the father is thinking this and wants to do this and wants to do that. The attorney's up there testifying, which attorneys can't do. Then the attorney's testifying to something that nobody can have personal knowledge of in the father's state of mind and stuff. He could have shut down the attorney from talking any of that talk that made him look bad. That's why you want to know the rules of evidence so you can shut out stuff that's not admissible. So, that being said, everybody knows that hearsay is not admissible. Everybody's heard that. If you ever watch Law and Order or everybody just knows that's the one thing that everybody pretty much knows. Irrelevant and hearsay. But there's an exception to the hearsay rule. So, in most states, hearsay is ER 802. It's adopted by the federal rules. Most states have the numbering system that the federal courts have. Places like California, New York, and a couple other places, they think they're so big and bad and cool and unique that they make up their own numbering system, which is fine. But there's exceptions to the hearsay rule, and one of the exceptions is an excited utterance or present sense impression, and both of them kind of sound a little bit the same. Like if somebody blurts, if I step on your shoe and you freak out and say, James, I'm gonna kill you, mother effer, or whatever, I could go tell the court that you said that because it was an excited utterance. You uttered it out under the stress or the excitement of the situation. A present sense impression is somebody talking about something right after the event, or they still have a present sense of it. I don't totally understand that one. I don't understand all the other exceptions. I don't even bother with them because this one is good enough because it's usually, kid comes home, Daddy, Mommy's boyfriend touched me and it hurt, or whatever. That's an excited utterance. So that's something, a lot of times real pertinent information or heavy information or hardcore evidence that you need falls under that category. So you should learn all the rules of evidence. I have a video on the rules of evidence in my store. everybody should learn the rules of evidence. 90% of people that I talk to don't know anything about the rules of evidence. It's the basic fundamental rule that everybody should know. That's why the best product that I could sell you or that's in my store is my rules of evidence video. It's an hour and 20 minutes long. Okay? That's way cheaper than if we did a consult for an hour and 20 minutes and you didn't take good enough notes, then that's your one shot at it. And it will cost you way more to do a consultation with me than this video. This video, you can go back and rewind it, or not rewind it, but go back in the place. It's marked where I talk about different rules and the time in the video, like, ER 402 is at 15 minutes into the video, and you can go right to 15 minutes and find it. It's the most important thing you should know when you have a court hearing. And so many people don't consult with me, don't figure stuff out because they think, oh, I learned that one point from James about court, so I'm ready to go to court. No self-awareness, no sense of urgency, no damn common sense to say, you know what, if I'm going to court, I need to learn everything about court. If I don't know anything about court right now, everything about court right now, so maybe I'll talk to James. Since he's been through 20 years of court and over 20,000 cases with other people, it might be a good idea to talk to James. It might be a good idea to get off my lazy ass and learn everything. Now, whether you learn it from me or not, this isn't a selling point. And I know people are saying, oh, he's not a really good salesman if he's sitting here trying to sell his services and he's talking real to us like that. You need to wake the hell up. You're not going to get this talk from anybody else. And I'm willing to tell the truth to people at the risk of them not coming to me and buying stuff. And if you see what I'm saying and you know that it's real and you don't contact me, then you weren't made for this anyway, because you're thin-skinned, overly sensitive, gentle, soft, tender, delicate feelings that got hurt. If you can't handle me talking about this like this, and I'm not even calling anybody out in particular, you can't even handle me talking like this, you're really going to have a hard time when a judge gets up. In boot camp, they have soldiers go through hell so that they're ready for the war they're about to be in. You're about to go to a war. And I'm telling you the real deal, and you need to wake the hell up and stop dancing around and pussyfooting around and being a sissy little bitch and saying, oh, the lawyer's going to handle it. Somebody else will handle it. I hope the justice system will work. Well, I'm telling the truth. It's just going to work. And if you have the damn common sense that God gave a monkey, you would realize, you see it on TV, somebody got framed. Somebody was in prison for 17 years until DNA evidence revealed it later. But you think you're entitled to just, I'm going to tell the truth, and I'm going to go in there and be nice, and I'm going to win. Who the hell do you think you are? Wake the frick up to reality. First of all, if you haven't been to family court, you'll get a hard dose of it once you go there. Second of all, you're not entitled to not ever get defrauded or wronged. There's innocent people who spent years and decades in prison. And you think the justice system is just going to work for you because you feel like it? You better get ready for war. Especially if you already got an emergency restraining order against you and all this other stuff, and you're shocked and like, well, let me just go tell the judge and I'll undo this. There's some stupid, either self-entitled weirdos or arrogant egomaniac pricks out there. You just think you're just going to walk in and you're just going to fix it. Or you're lazy and shiftless and you don't want to prepare and you're just hoping you get lucky. Now, some people do get lucky and they go in and they have a good result. Or their baby's mom surrenders because they didn't want to go through with it and they don't want to fight that hard. But the vast majority of people in contested cases, you're about to go through hell and you're worried about me talking harshly in general, and I'm not exposing you and putting your address and your birth date and your social security number out here. There's something wrong with you if you're going to get easily offended at me telling the truth that you need to get your ass in gear and get ready for the fight of your life. Or if you've already been in it and you're still dilly-dallying around and you're hoping and wishing and praying and thinking that everything's going to work out okay just because you deserve it, you need to wake the hell up. And you should learn everything that you need to learn, even if you have an attorney. If you're dumb enough to keep an attorney that's screwing you over and over and over again, you should at least learn how to light a fire under them and make them do their job. I just had somebody, their attorney was talking smack to them and blowing them off. We wrote a letter to them and all the attorneys at the firm. All of a sudden that attorney is, on their P's and Q's, like, how can I help you? Are you going to fire me? Well, if you could do your job, no. So anyway, evidence rule 803, but learn all of it. Learn everything.